So before we get started, I just wanted you to explain to folks what are employee rights and why is it important for everyday employees, especially racialized employees, to be informed of their rights.
Okay, yeah, perfect. So before I get into the employee rights, let me just kind of add a little bit that's relevant to what we're talking to today. So I've been practicing law for just about 10 years now, and I advise employers and employees, and I think that's helpful to kind of have both perspectives. And so I think it will be helpful in this conversation. So when we talk about employee rights, these are protections that every single employee has, regardless of how big the business you work for or work at is, or how small. So if you're at a business of one, you're the only employee, it's you and someone else, you have uh, significantly the same rights as somebody who works at a large corporation. And so these are rights that you have just as a result of being an employee. The reason why that's important when we talk about racialized workplaces, or excuse me, racialized employees, is often I hear about situations that I would understand being racialized, comments, situations regarding to being passed up for promotion, um, things that are happening regularly, and I think it's important that we know what our rights are um, moving forward. And so, once again, these rights they apply. Doesn't matter which province you're in. It doesn't matter whether you work at something under federal legislate or federal jurisdiction, like an airport. You have these rights, and it's important as racialized professionals that we know what they are.
Awesome, thank you. I think some of the challenges that some of our clients and community members face is experiencing discrimination from employers or within the workplace itself. So when it comes to employee rights, what are the steps that employees or employers could take if they experience discrimination in the workplace?
Yeah, that's a big question. And so I'm going to try to break it down. And so I think at the very first instance, when you feel like you've uh, experienced discrimination, the most important thing you can do is write it down somewhere, anywhere. Put it in your phone, um, create a Word document. It doesn't really matter. Write it down on paper, but it's important that you write it down in real time. And here's why. When you call a lawyer, and your lawyer is asking you questions like, well, what day did this happen on? Who was there? What was said specifically? What was said? You're going to have in real time. You're going to have a better knowledge and recollection of that than if some time has passed, months or years. And so, it's important when these situations occur. Please write them down in real time. Write them down as soon as you can, so that you have a just a better record because um, in law, obviously we hear about kind of this quote unquote he said, she said, but if somebody has something written down in real time and the employer is saying, well, I don't think we would have done that, or I don't recall, but I have no record of it, whose evidence is stronger? And so that's one of the most important things I could say is one, you want to write it down. Two, after you've determined, okay, maybe I want to move forward here, um, certainly talk to a lawyer. Doesn't matter where you are in Canada. We live in an era right now where access to legal services has not been more affordable. Um, as in, you could almost anywhere in the country, you could speak to a lawyer within a day or two for free. Uh, a lot of lawyers, especially employee side lawyers, are doing free consultations. All you need is 20 minutes to ask the questions to say, okay, this is what took place. What are my rights? Should I move forward? Can you give me some thoughts? And so the second thing is don't be afraid to reach out to a lawyer. It's easy to find somebody for free. Um, and you can access a lawyer very quickly. I guess I could stop there. I mean, we might go into kind of the human rights process, but at the very first, write it down. And then number two, don't be afraid to reach out to a lawyer. Consultations are often free.
So I had two questions, but let me figure out which one to ask first. Because I was gonna say, write it down. Writing it down is essentially evidence, right? Um,
Yes.
and so let me ask this first then. Okay, when it comes to evidence, then writing it down, that's just to keep track of everything on your end. Um, why is it so important when it comes to legality? Why can't I just say, hey, this happened on this day, and you believe me either way? What's the importance when it comes to legality?
Yeah, so that evidence is the most important part of the case because um, these cases are inherently fact specific, as in we need to determine what actually happened. And so once again, writing something down as early as possible is helpful. And so, there's different types of evidence. Often I talk to people over the phone and they say, well, this was a face-to-face contact or conversation. I don't have any evidence. And I'm saying, no, that is evidence. You're giving it to me right now. I mean, we understand that everything isn't going to be in a text message. Everything isn't going to be in an email. There are going to be comments, especially if you're at in the workplace, that are going to be face to face comments, which may be discriminatory. Um, it's important that you record that, and that evidence has weight. It has even more weight if you record it in detail at the time. But then, just kind of keeping on the conversation of evidence, there's direct evidence, there's documentary, and so once again, emails, texts, WhatsApp, hold on to those. I don't know how often I deal with cases where people say, "Yeah, I had it at the time, but yeah, I let it go," and so it's one of those things where if you get that feeling in your stomach that this isn't right, and I might want to record it because at the very least, you don't, if you don't use it, you don't need it. Okay, that's fine. But if you ever need it in the future, you definitely want to have it there. Not to say it's fatal if you don't have it, but it's helpful and it will help the case. The other reason why evidence is important is at the first step of any human rights complaint, uh, the burden is on the complainant first to show what we call that there's a prima facie case of discrimination. What does that mean? That means that if I give an account of something that happened to me, a prima facie means at first instance, just from hearing it, does this amount to discrimination? And so the more detail you can give, the better. Before I finish, let me just talk about one last thing, one last piece of evidence. It's circumstantial. And I just want to talk about this because I've got a call recently. Now, this wasn't strictly related to anything racial, but this was arguably discrimination on the basis of sex. This was pregnancy. And so the story is I was speaking to an employer who told me that they terminated an individual uh, 2 days after she informed them that she was pregnant. And so I said, okay, they were concerned about a human rights case, and I said, okay, well, were there any reprisals, any issues with her performance prior to the termination? Yes, they said. I said, okay, well, did you tell her about that? No. And so you talk about circumstantial evidence. Um, if she wanted to bring that claim, and this is the advice I gave them, I said, well, circumstantially, if she tells you she's pregnant and 2 days later she's terminated, the fact that you say that you had issues with her performance, but the fact that you didn't go to her circumstantially, that weighs towards discrimination. So that's the third piece where you don't have direct evidence, but we can infer from the situation.
That's really good information. Thank you. Um, what I was going to ask before is, um, I think for racialized folks, it's oftentimes that we feel like we don't want to exacerbate the issue. We don't want it to become bigger if it's an issue between us and our employers. Um, so when is it appropriate then to say, okay, I'm going to contact a lawyer to get information? Because I know this is the part where people get super nervous about. They might go to HR, HR might not help, still afraid to go to a lawyer. So please advise us as to when you think it's important to tap in and go to a lawyer.
That's such a tough question. That's such a tough question. Personally, I would say go earlier because I find I talk to a lot of people who go through their story and you say, well, you've been putting up you've put up with this for 18 months, for 2 years. You kind of wish that they would have at least spoke to you earlier. And so the reason why I think you should talk to a lawyer earlier is one, I mean, it's your workplace, you're spending a lot of time there. Um, that's just added stress, right? Like just law aside, dealing with that and being in that workplace that is toxic, that doesn't respect you, where you're subject to racial slurs, this just isn't good for you as a person. And so, to me, once again, the cost of talking to a lawyer at the outset is it's none. It's minimal, right? It's just a call. And so I think it doesn't hurt. You're not, once again, you're getting a free consultation. That lawyer's going to say, okay, well, based on what you told me, I think you got a strong case, or I think your case uh, lacks a little bit of evidence here, and then here are the steps. But I think if you look kind of way between, should I kind of hold on to this and wait longer, or should I reach out? I think you should reach out because that lawyer will be able to give you uh, a better kind of perspective on your case. But that's a tough question. It really is.
I guess we would say that it doesn't hurt to speak to a lawyer to just get information, right? And I guess that would support you in the long term because depending on what you're advised, you could determine what you want to do going forward. But I would say, on a personal level, I know there's been many situations where I'm like, no, I'm too scared to get into legal troubles because I'm a racialized person. It's probably I'm not going to be taken seriously. So this takes me to kind of our next question when we talk about Ontario human rights and Canadian human rights, right? So tell us a little bit about the Ontario Human Rights Code and how we could utilize that as employees in the workplace.
Yeah, absolutely. So Ontario and every province has its own human rights code. I'm just going to talk about Ontario because that's where I live, that's where I practice. Um, Once again, if you work in an airport or a federally regulated workplace, then you'll have the Canadian Human Rights Act. So everybody's covered by some type of human rights code, and they're all very similar. And so first, we look at what is a prohibited ground of discrimination. And so for the basis of this talk, uh, color, ethnic origin, race, religion, a number of different age, marital status. These are prohibited grounds of discrimination. And so when you're formulating, okay, what do I want to move forward with this, or just even putting it together in your mind first, okay, do I have a prohibited ground of discrimination? One thing to remember, they don't operate as silos. And so, recently I got a consult from an employee who was receiving derogatory comments about Ramadan. And so there's a religious aspect, there's an ethnic aspect as well. And so often you're getting a number of different grounds of discrimination. That's first. Two, if you wanted to move forward with the process in any province, you're going to file a complaint. You don't need a lawyer to do that for you. You definitely would want to have a lawyer to kind of speak to a lawyer at the outset. You don't have to have the lawyer file a complaint for you. It's definitely helpful. Paralegals will also do it, and they can do it at a lower cost. But you want to file your complaint, and in that complaint, that's where you're putting in as detailed as you can your information, your evidence. And so whether that's written evidence, whether that's your account of um, face-to-face conversations, whether that's circumstantial evidence. And so once again, I use the pregnancy example. There's recent examples and kind of more towards the racialized space about promotion, and we'll probably talk about that a little bit later in the Q&A, where um, racialized employees are saying, well, we're looking at who's being promoted, we're looking at upper levels of management, and we are being blocked out of this. That's inherently a little bit difficult to prove, but you can prove it, and it's been, those findings have been made. That's circumstantial, and so you're going to put that in the complaint. I think the more for something like that, when it comes to promotion, that's where you want your complaint to be even more detailed, because that likely isn't just going to be your own evidence. You may need to speak to other witnesses in your workplace as well. Um, then after that, uh, the employer they'll get notice of the complaint. And I want to talk, before I finish this, I do want to talk about retribution or retaliation, because I know a lot of people are concerned about that. Unfortunately, quite rightly, like a lot of employers um, make really bad decisions. One in the discrimination, failing to addresses discrimination, and sometimes retaliation. But I can say that every code, the Human Rights Act, strongly punishes employers for that. And so, um, if that ever does happen, I think it's important to know that employees are very strongly protected against retaliation. While I'm on the retaliation part, not just protect against retaliation for filing a complaint, you're protected against retaliation if you go to HR, um, and then later on you're treated differently. Uh, that's covered. If you're in a workplace where it's small, there is no HR, you're going to the person that potentially is the issue, you're still protected. That's a very strong protection, and maybe we can get into that a little bit later. But it's important to know, no matter where in the process, courts come down very hard on employers that retaliate, that isolate, that treat employees differently, who make complaints, but also who are witnesses. Often, there will be workplace investigations. You should not be punished or isolated for being a part of an investigation um, regarding kind of another employee as well. Very strong protection. So after the complaint's made, uh, the employer's given notice, uh, they'll have a response. There will be a mediation at some point. Often cases settle at mediation. I'll tell you, having represented employers, will be surprised to nobody that often money dictates a lot of decisions. And after mediation, when one, the employer is paying the lawyer to be there, the lawyer's not cheap. But two, often if it's a case with merit, the employer is saying, the lawyer saying, hey, we can pay this out now and try to resolve this, or you're going to have bigger exposure later. And so I know a lot of people are often concerned about going to hearings, kind of going to trials. Often it never makes it there. It resolves in mediation, as often it should. And then if it doesn't resolve in mediation, then you're going to go to a hearing. So that's, in a nutshell, the process. Once again, doesn't matter whether you're in Ontario or any province, that's the general process that's going to be followed.
Thank you for that. I was going to ask, so explain the difference now between the provincial human rights code and then the Canadian Human Rights Act, and how we would access the different supports
Yeah,
from them.
great question. The principal difference is really your workplace. And so most workplaces are going to be under their provincial code, but some workplaces are under federal jurisdiction. And so I use the airport example, where airports, we know that's federal jurisdiction. And so if you're at CBSA, or you work, I read a case about someone who does private security at an airport, that's where you're going to have access to the Canadian Human Rights Act. And so really the only difference, the only big difference is your workplace itself. And so that's where you speak to a lawyer at the outset. The lawyer will say, okay, no, you're going to want to go provincial, or no, your workplace is in the federal sphere, so you're going to go uh, to the federal sphere under the Canadian Human Rights Commission.
Okay, thank you. I have an interesting question here. So for many organizations, they have like some policies, right? Discrimination policies, all of these other things to prevent anything like that taking place, and having some structure of how to hold people accountable. Now, there's some organizations that don't, or companies that don't, because they're new. So
Yeah.
now, if you start at a company, they don't have any policies yet, you're getting paid, you're doing your work. What do you do in that case when there's no HR and all of that? It's a small corporation. How do you handle a situation like that?
Oh, that's tough too. Here, I mean, I mean, legally speaking, and this is also case by case. It depends on the relationship, but every workplace should have policies. There's no good reason not to. If you can hire an employee, because there's steps that you need to do to hire an employee, you're paying taxes to CRA. As a part of that, you should have policies. Um, it's not hard to find. There's a lot of good examples, best practices. There's a lot of great resources. And so to me, I don't think there's any good reason not to have policies in place. Now, whether if you just started and you want to kind of hand that over, I mean, I leave it to kind of everybody to navigate that. I find personally often employers are uh, perhaps, I don't want to use the word ignorant. I think it's a bit too strong. But perhaps this is something that's overlooked. Maybe I'll use that word where it's just considered, okay, well, I don't need this to operate the business. Like this isn't critical to the operation. And so it just always gets pushed off. And so that's why, and I've seen very positive examples where employees have just kind of sent a draft and said, hey, I thought I might just send this over to you for your review. Do you have any issues? I think it'd be good if we adopted this to kind of do the work, at least present the work to employers. But in my experience, often employers don't have that, have things in place. So often we're talking about small businesses. Small business owners are run rampant. I mean, it's tough, and it's often, I say, it's one of those things that just gets pushed down the road. Yeah, I'd like to have something, but you never actually get to do it. So
Yeah, and I know you support small businesses, so I'm sure you
yeah,
see this often, not necessarily complaints, but you do work with both ends, the employee and the employer. And so I think it's important for both sides to also protect themselves in situations like this. Um,
yeah.
but
So,
sorry,
sorry,
go ahead.
before we move on, just to add in there, what I tell my small business clients is I say, this makes your job easier. You think that this is added work, putting in a policy. No, this makes your job easier because if something takes place, what happens all too often is workplaces aren't equipped because they haven't considered it. They don't have any policies in place. And what often happens, in the case where um, it might not be at the management level, it might be comments coming from an employee to another employee, because the workplace hasn't considered it, they don't take proper action when the complaint cuts for them. It's just it's kind of, they're paralyzed, and that's not a good reason. Human rights commissions say, well, tough, you have an obligation here, you need to act on it. And so I say, this is going to save you because yeah, you're busy and things are going to happen. So why not have something written there that tells everybody what you're going to do, how you're going to proceed? The other reason why it's important is, I mean, often these issues are, they could potentially be litigious, but um, there's some hostility, there's some negative feelings. And so I think it's really important to be able to point to a policy and say, we're not treating you any differently, we're going to follow the policies here, we're going to do this. And so I think that often gives employees um, kind of a sense of kind of safety, if you will, to say, okay, well, this person isn't just making it up. I mean, these are the company policies, and so it's important to have. But really, from the small business side, it makes your life easier to have it in place.
Thank you. What I'm realizing as well is that while companies may have policies, there's potential that they may not necessarily align with the Ontario Rights Code, or they may not include some things that are essentially part of our rights, right? And so we may not necessarily be aware. So for the employer or the employee who started at a new company, um, how would you advise them to become acquainted with what their rights are? I know when I
Yeah,
started at, this nonprofit a while back, first thing my supervisor said, she's like, here's a policy book. I'm giving you guys 1 week. Make sure that this is your
yeah,
task, and ensure that you know what, your rights are and the policies that exist. And so what's some further advice you could offer?
yeah. I'm so happy you asked that. One of my biggest pet peeves is when I go into a business and there's an issue, and they say, well, that's the policy. And I just want to say, but that's not the law. like, like, okay, you can write down the policy, but the policy has to be derived in accordance with the law. And so, just to use a specific example, actually, before I get into that, um, one, every company policy, the human rights code trumps the policy. And so you can't, the company can't opt out of it. They can't, nothing they do trumps it. And if they do have a policy that isn't in line with human rights legislation, that policy is null and void. And so there's a lot of examples of companies kind of having policies that are discriminatory. There's a number one I could use is, and don't joke, it's not because you have braids. I already was going to use this example, but there are, sometimes there are dress code and they say, well, okay, employees can't have braids. Well, why not? Is this a bona fide occupational requirement? Um, there's, other things about particular dress code. Okay, well, why is the dress code exactly like this? Can we not accommodate this employee? And so one, you have to be in line with the human rights legislation, but two, if somebody comes and says, okay, well, I've this is one cultural, this is a cultural belief, this is religious, or kind of this is just how I carry myself, um, I would like you to make an exception here. Often companies will say, well, no, you're on the team, we got to treat everybody equally. That's not the law. The law actually is, if you're discriminating or if there's a difference on a prohibited ground, the employer has a duty to accommodate. They have a duty to accommodate. And so we don't hear this enough. I think I need to emphasize this. We often hear, okay, well, it's a policy. We just got to follow the policies. Oh, I don't make the policies. You have a duty to accommodate. What does that mean? That means you can't just say this is the policy. You have to take a look at the request for the exception and say, can I accommodate this request? And so if it's a dress code request, can I accommodate it, or up to what we call undue hardship? And so if the accommodation would be just kind of commercially impossible, okay, you don't have to do it. But up to, that's a high bar. Up to undue hardship, you have a duty to accommodate when it comes to these types of issues.
Thank you. And when it comes to duty to accommodate, right? You mentioned the example of um, the hair, my locks, right? I think it was the Canada's Wonderland a few years ago. They're under fire because they let some girls go because they had braids, right?
Yeah.
Now, if we use the example that you had before in terms of a pregnant woman or someone who announced to their employer that they're pregnant and they get let go. Now, if they get let go, is there still a duty to accommodate? Do they have to bring them back to work? Is this another issue? Like, how do you navigate
Yeah.
that?
Oh, you mean after you've been let go, after you've been terminated, what
Mm-hmm.
recourse do you have?
Yeah.
Yeah. So quite a bit. Financial, I'll get into, and non-financial. And so commissions have the power to reinstate your employment. That can happen. Um, Often, what you see is financial, strong financial, um, I guess, disincentives. And so, one, you look at what we call in law damages, but damages is basically our way of saying money lost. And so, lost wages, right? So, if you've been terminated for a discriminatory reason, all the wages, all the salary you would have made, those are your damages. You're entitled to get that money back, and then anything flowing from that. And so, you're terminated. You're probably looking for other work. Maybe you have to take the bus. Maybe you're doing this or that. You're incurring other costs um, to get another job. So anything monetary that's included, you're entitled to get that back if your claim is found to be valid. The other part, and this is the big thing for employers. This is why, as I said earlier, a lot of claims don't make it to a hearing because the other part is what we call general damages. General damages are for pain and suffering. And in Canada, when it comes to human rights legislation, human rights commissions are not afraid to make pain and suffering awards. They happen often, 10,000, 20,000 and up. And so as an employer, once again, you have a complaint against you, and you're looking at a potentially large pain and suffering award. uh, it doesn't make sense to push that to a hearing often. And so these are the types of things you see. You can be reinstated. You can be compensated, and then there's the pain and suffering part, which in human rights legislation, there we award it. I think, or commissions are fairly generous with it.
Thank you for that. I also think about the recruitment process and
Uh, yeah,
discrimination people face during recruitment. Now, I I would assume it's a bit harder to hold employers accountable for discrimination during recruitment. What's some information you could advise us in terms of people who feel like they did face
yeah.
some kind of, discrimination due to their race or any other issue?
So yeah, let me, because you're right. Inherently, it's a bit more difficult because you didn't get the job. All you have is that interview or that process. Maybe there's emails as well. So let me say an instance where it might be a little bit on the easier side to prove. If you're in an interview process and at any point rude comments or racial comments are made, at any point questions are being asked, and that's the other thing. There are prohibited questions, and so an employer should not be asking you about your religion or your marital status or things like that. So if you leave an interview and you've had kind of these comments, these questions, these offensive jokes, I would say that's that would be a fairly strong claim if you can kind of prove it. Or excuse me, if you have it kind of outlined, that's a fairly strong claim. Um, so that's where it's a bit easier. Um, the other part where it's a bit more difficult is, and so many businesses and workplaces do this, where the question is, well, how do you recruit? Are you recruiting exclusively from word of mouth? Because if you are, you're going to have some blind spots. The word of mouth, well, it's only going to go as far as the existing people in your organization. What does your organization look like, right? Are you recruiting using particular events? Okay, well, what events are those? And, are those events being held on religious or cultural holidays? Um, are these exclusively drinking events? I'm in law, and so I used to have a podcast. I talked about this a lot, where law is kind of rampant with bias in recruitment. Um, unconscious bias, where they often talk about fit. Oh yeah, well, we hire based on fit. What does that mean? I ran my own law firm for 7 years, and we would recruit. We would say, we don't care about fit. What does fit really mean? We don't want fit. We want good people, good lawyers. And so one thing you often see is, hockey events. I have nothing wrong with hockey, but once again, like, hockey's expensive. I didn't get to play it growing up. If you're, doing these types of outreach, hockey, golf, you're excluding people, either unconsciously or consciously. And so you see this a lot in law. And you see it obviously in other workplaces as well.
Thank you for that. I see we're starting to get a bit of questions in the Q&A box, and we have about 20 minutes left. I have one more question to ask you here, and then I'm going to open it up to the Q&A. So I encourage folks who are on the call, continue to add your questions. We'll get to it in a moment. The last question I have for you here is, you know, you just mentioned unconscious biases, right? Um, but then there's, of course, conscious bias. And then you can't always prove this. But when it comes to promotion, right? We often hear how racialized people are overlooked when it comes to promotion. They may be doing I don't know, the CEO's work, but they still get overlooked for promotion. So how do we support racialized professionals that are experiencing situations like this?
I mean, in short, what you're doing, what Culture Check's doing, is great. Having resources, but I want to tell a story about this that involves the Canadian Human Rights Commission. And credit to you, Dobie Joki, we spoke a few weeks ago, and you actually brought this to my attention. And so the story is, and this is actually just came out recently, the finding. And so in 2020, a number of racialized employees at the Canadian Human Rights Commission, okay, they are the adjudicator for human rights disputes. They alleged that they were being discriminated against on the basis of their race, um, particularly not being held out of opportunities for a promotion, um, networking events, formal networking, informal networking events, being isolated from comments, slurs in the workplace. Once again, we're talking about the Canadian Human Rights Commission. I mean, it's kind of, but I think there's a kind of a good spin here at the end. Uh, and there was another that escapes me, another ground. And so that was in 2020. Just 2 weeks ago in mid-March, the government treasury took a look into it and concluded that they were right. They investigated, they concluded that yes, the Human Rights Commission was in fact discriminating against its own visible minority employees. And that came out 2 weeks ago, and now they're working on a process to ameliorate that. Oh, and the other piece that I forgot, uh, the employees were finding and were raising the issue that race-based complaints were being dismissed at a much higher rate than non-race complaints. Further, the adjudicators on the commission who were taking a look into the complaints didn't have any training on race-based complaints. Now, obviously, if you had something related to sexual harassment, you would want people looking into it that had some type of training that might inform or help them make with that decision. So the government did find that there was discrimination at the Canadian Human Rights Commission. Now, somebody might be listening and saying, how could that possibly there be anything good to come from the fact that the place where we go to regulate this is by the mission of our own government engaging in discrimination. Why I think that's good is because it's out there now, particularly with respect to promotion. And so the promotion, that's always a piece that's very, everyone, it's hard to prove. And I think the fact that we had that finding 2 weeks ago from the Canadian Human Rights Commission opens us up now for other private workplaces on how to be successful with these claims. What does it look like? What is the evidentiary burden? And so, not a great story, but to me, I think that there's the positive outcome is, okay, well, they went through it. They went along ahead with the complaint and they won. And there's lessons to be learned. So
Yeah, very interesting scenario. Very, very
mhm.
interesting scenario with the Canadian Human Rights Commission. Um, but okay, let's get into these questions from our participants. Thank you all for submitting questions here. Let's try to get to them. We have about 15 minutes left. So the first one here, um, would love to know my rights with regards to taking my religious days off with pay. My employer gives everyone a week at Christmas off paid. However, Muslim employees who observe Ramadan and would like to celebrate Eid have to take vacation days. What are my rights here? Do I have the right to get Eid off with pay without taking vacation days?
This is a great question. And like most legal answers, there's always a gray area. So for here, my first thought is this. Is there, when we kind of go back earlier to when I talked about a duty to accommodate, is there a reason why you cannot be accommodated, a bona fide reason why you cannot be accommodated in the request to have Eid, a week off for Eid, in lieu of Christmas? I don't see a good reason as to why that accommodation couldn't be made. If other employees are getting a week off for Christmas, then in lieu of that, why couldn't you get a week off or something um, similar for Eid? So, I look to accommodation from what you've told me and just kind of my first instinct. I don't see a good reason why that could not be accommodated or something could not be worked out. Um, but obviously, don't take none of this as legal advice. Like, I don't know the whole situation, but my first instinct is I just don't see why your employer could not or would not have a good reason to make that accommodation. To me, that seems reasonable. And these are the exact types of issues that we talk about when we talk about discrimination at the workplace.
So when you say in lieu of, you mean, okay, since I want to take days off for Eid, I will work during Christmas and then I'll have my days off during the time that I have my religious celebration. Is that what you
Yeah,
mean?
perhaps like to the extent that that could be accommodated. So maybe the business itself is shut down for parts of Christmas. But I guess the point is, without knowing any more information, I would think that the employer could accommodate, could kind of work something out where, okay, maybe she does a little bit of work during the Christmas week or something to kind of just offset or balance. Where once again, the idea isn't that we're all treated exactly equal, right? I mean, everybody doesn't celebrate Christmas, and so there's no reason why we couldn't move it around. I think once again, you have a duty to accommodate, and so without hearing anything more, it makes sense that that's something that the employer should at least kind of look into accommodate.
Okay, thank you for that. I hope that was answered for you. If not, you could submit a follow-up question. The next question here, how can BIPOC employees ensure that employees are not discriminating against us based on our race, ethnicity, or culture?
I mean, one, I think it's informing yourself. There's a lot of great resources online, but like I said, you can reach out, you can speak to a lawyer. That's one. Two, like I mentioned earlier, um, proposing policies on this to your employer if the employer doesn't already have them. I didn't mention this. I wanted to mention this earlier. Proposing a committee, a diversity, equity, and inclusion committee in the workplace. That's a great practice. And so there's things we can do to make the workplace itself, to suggest that to improve the workplace, to make it more inclusive. Those come to mind. And I guess
Thank
the other
you.
thing, and sorry, I guess the other part too is, because I think the question was, ensuring that the employers aren't discriminating. Obviously, we can't ensure it, but the question is, when we see it happening, what do we do? And so I started out saying it's important to record examples. Well, they don't have to just involve you. If you see it happening to somebody else, you can also record. And I think that's one way we keep everybody honest and we have an accountable workplace.
That goes straight into the follow-up question, which is, what steps do I take if I witness discrimination or harassment in the workplace? If I could just like preface a small story prior to you responding, I was at another workplace and I felt like I was experiencing harassment. And so I told another employee that I didn't want to make a complaint because I was extremely scared. I didn't want retaliation from that other employee. And he was like, I'm going to take it on my behalf and I'm taking it to HR. And I'm like, no, that's not what I want. And he's like, now I know. And I recognize that I've been witnessing it. And so I'm going to make the complaint on your behalf. And I was so afraid because I'm like, I didn't want to do it myself. So
Yeah,
I feel like with this question, what steps do I take if I witness discrimination or harassment? Part of it also is recognizing that there must be communication with the person who has experienced that harassment, I feel. But you could
I agree.
respond.
No, I agree 100%. Um, and so, yeah, having that communication. Uh, I hesitate on this other part. I mean, in some instances, it does make sense to talk to other people you're close to at work. In some instances, that doesn't make sense, but I kind of leave that up to everybody's kind of judgment there. In some cases, it does because somebody can say, "Oh, I witnessed that as well," or "I witnessed something else." Once again, recording it, and if somebody comes to you, cooperating, not being afraid of retaliation. I think that's the biggest thing. to not be afraid of retaliation or reprisal. Obviously, nobody wants to lose their job or to be kind of in a toxic workplace. But if found that the employer did retaliate against you, the penalty is so punitive. It's so much worse for them than it would be for the employee. Now, I still know it's tough, but I think it's important to know that you have a strong protection against retaliation.
Thank you for that. Um, Okay, the next question. I think folks want to understand how to build a strong case if they're going to pursue legal action. I know you said, the evidence is important, writing things down and then keeping track of things. Are there other elements that you think people should think about, or are those the key things?
I would think about it. I mean, when I get a consultation and somebody tells me the story, I'm thinking about a few different variables. One, dates. What are the dates? It's not sufficient to say this happened. When did it happen? As specific as possible. We might not be able to get the exact date. The more specific, the better. Two, who was there? And so, if you want to build a strong case, we need to know, did anybody else hear or witness it? Why? That person's a witness. Uh, and so witnesses are going to help your case. So are there witnesses in any occasion? It's the other part on building the strong case. Once again, preserving anything documentary. Um, Maybe I'll just stop there, but I think those big things is date, um, identifying potential witnesses, um, and then the other part, I'll say one last thing, um, as specific as possible. So if we're talking about spoken words, so if the issue is comments or slurs or jokes, you need to write that down in as much specificity as possible. All right. And so what's a bit of a weaker allegation is um, I was discriminated against based on race. Okay. How? What was said? And so get into, if it's a joke, recount it. If it was a comment, recount it as best you can. That's how you build the strongest case. It's based on detail.
Thank you. And I think I would emphasize that as well in terms of detail, which is why it's important to write it down immediately or, document it in some way immediately so you can remember as much detail. Um, Another question here, which is really interesting, I don't want to miss this. I was offered general damages from my employer, but it came with a non-disclosure. I refused the payment because I felt it silenced me in the process of accepting justice. Is it normal for one to be offered general damages and sign an NDA?
Yes. So I represent a lot of employers. Um, I'll almost always ask for an NDA if there's going to be a payout. Almost always do that. And so it's very common term, not to say there's no legal advice here. I'm not to say you should or shouldn't sign it. Um, but it's a common term that I would include in any settlement.
Thank you. Um, we have two more questions here. What are the different types of racial discrimination that can occur in the workplace and how can I identify them? There are some of the obvious, but sometimes it's systemic and not everyone can easily identify them to even know that they're being wronged. This one's interesting.
Yeah, and so I mean, I won't talk about any of the kind of the overt, obvious examples, um, but I think going to the earlier question about the week off, um, that can be discriminatory based on how it's applied. Um, Flexible work hours, dress codes, things like that. So it it depends. There isn't kind of a set in stone list of things. It kind of depends on, well, how does this work in practice? A policy is just a policy. What effect does it have? That's what we're looking at. And so there is, like, the list is kind of unending. It depends on how these things affect employees.
Thank you. Okay, and the last question here. Racism and discrimination can take so many covert forms. Sometimes means being excluded from projects, not being invited to essentially on the side. Simultaneously, this employee had experienced some kind of in the work. How do you prove discrimination with these kind of nuances? What
Yeah,
does record
I,
keeping look like in these situations?
I think that's a great question to finish on. I think that's excellent because so many of these allegations these days, this is what we're talking about here. I mean, it's not as overt where it's comments or jokes or slurs, though that that might have a place. But it's once again not being invited to meetings, not being kept in the loop, not being invited to things outside of work, everything that was listed here. And so, and keep in mind when I told the story earlier about the Canadian Human Rights Commission employees, this is what they were talking about. This is what they're talking about. And so, how do you build that case? Same principles, um, dates. And so, obviously, there's more going on, but you still want to record it. So, which meetings are you not being included? Right? Not being kept in the loop. I know it can get tedious, but that's the nature of it because that makes it a lot easier if you ever decide to move forward. Um, and so, just once again, detailing these instances in and of themselves, they may seem small. In and of themselves, they may be explained away, but this goes to circumstantial. You say, okay, well, if this happens once, it could just be nothing. If this happens over and over and over and over again over years, this is discrimination. And the only way we can prove it is by giving as much detail at each, once again, recording on your own. So whether that's in your phone, whether that's documents, record on your own each single element in as much detail as you can. Once again, identifying the date, who was there, how did the communication take place, and then if it's anything written, or excuse me, if it's anything spoken, write down what was spoken. If it's a meeting, okay, what meeting was it? Who was invited? Is this, and here's a big thing. Here's a big thing. If this is a meeting that directly impacts your job description, if this is under your purview of what a meeting that you should be in on, what is the basis for you to be excluded from that meeting if that's happening over and over and over again? So when you're recording it, well, that's an important thing to say. I mean, is this a meeting that impacts or is related to your job description, or is it unrelated? So we want to record that because if that comes to me, that makes it a lot more easier to make the argument to say, okay, well, they're going to say, well, it's just a meeting. Oh, we had it informally, but this is her job description. Why would you exclude her from this meeting and this one and that one? And so that's very helpful.
Awesome. Thank you so much. Another quick question came in. I'll quickly give you the summary of it. But essentially, if you have an issue with your when experiencing discrimination in the workplace, would you recommend that someone first connect with their manager, supervisor, or immediately go to HR when it has to do with something like discrimination and racism?
I mean, legally, this is, yeah, I mean, legally, you can go to HR or you can go to your manager. I'm just kind of practical with it. HR really should be like if HR is working the way it should be, HR should be the first step. There may be instances or reasons in your workplace why that wouldn't take place, but the goal of HR is to be that first step. And so that's where it probably should go. But once again, I leave it to you in your workplace. If for whatever reason you feel strongly that you have a better chance of being heard and having a constructive conversation outside of HR, though that's not the way it should be, that might be the case, then you can do that. There's no kind of hard or fast rule on it, but my thoughts are, well, that's exactly what HR is there for. So that enough in of itself might be a problem if you don't feel comfortable going to HR.